This courtroom battle just crossed a line. Subpoenas blocked lawyers under fire, and a judge quietly losing patience. What really happened behind those filings? And why could the next move change everything? Stay right here, because once you hear this, nothing about this case will feel the same. Courtroom chaos erupts as the case enters a new phase that feels heavier, darker, and far more unpredictable than anything that came before. Because this is no longer just about claims and defenses, it is about control, pressure, and the limits of power inside a courtroom that is clearly reaching its breaking point from the very first moment the judge steps in to block the subpoenas aimed at Justin Baldoni's legal team. The atmosphere changes instantly, because what was supposed to be a dramatic breakthrough for one side instead becomes a stark reminder that not every door can be forced open, no matter how loud the demands become. The filings have been relentless, coming in waves day after day, stacking tension upon tension until even seasoned legal observers admit this docket has become overwhelming, and that alone sets the stage for what feels like a turning point. The judge does not shout. He does not grandstand. He does something far more unsettling. He slows everything down, and when a judge slows a case like this, it sends a message to everyone watching that someone is pushing too far too fast, and that consequences may not be far behind. The blocked subpoenas land like a cold splash of water because they strike at the heart of what one side hoped would expose everything, yet instead they reinforce the wall of privilege that protects attorneys and their clients. And that moment alone shifts the balance of fear and expectation. Throughout the case, as the reasoning unfolds, it becomes clear this was not a casual decision, but a carefully measured response to a situation spiraling toward excess. The judge examines the requests one by one, separating them into categories, and that methodical approach is itself a warning, because it shows the court is paying attention to details, not narratives, not headlines, not public pressure, but the precise scope of what is being asked. The first group of requests collapses almost immediately because the court is told the documents simply do not exist. And in that instant, the fight evaporates, leaving behind frustration and suspicion but no leverage. The judge accepts the representation made in open court and moves on without hesitation, signaling that unless proof of deception appears, speculation will not be enough to keep this issue alive. That moment is quiet but powerful, because it demonstrates just how much trust and responsibility attorneys carry when speaking before a judge, and how quickly a path can close once the court decides to accept their word. The second category brings a different kind of tension, because here the judge does not say the information is irrelevant or forbidden. He says something far more dangerous to one side's strategy. He says there are other ways to get it. This is where suspense tightens, because the door is not locked, it is simply guarded. The judge points out that these requests are overbroad, burdensome, and potentially invasive, and that allowing them would risk crossing boundaries that courts are designed to protect. He emphasizes timing, context, and proportionality, reminding everyone that discovery is not a weapon, but a process, and when that process becomes too aggressive, the court will step in. The phrase "without prejudice" hangs in the air, because it carries a double meaning. It is both a denial and an invitation, but only if the requesting party can later prove they exhausted every reasonable alternative. That is not an easy bar to meet, and everyone knows it, which makes this denial feel less temporary and more like a strategic dead end. As the discussion moves beyond paperwork and into public perception, the stakes rise sharply, because now the courtroom battle bleeds into the media landscape, and that is where things become truly volatile. The question shifts from what can be demanded to what can be said, and that line is far more difficult to define. The law allows parties to defend themselves, to speak about ongoing litigation, and to respond to accusations, especially when those accusations were first made publicly. Yet the tension grows as one side frames these responses as improper, as retaliatory, as part of a broader narrative designed to influence opinion rather than clarify facts. The judge has not ruled on this directly, but the mere presence of sanctions in the conversation creates an atmosphere of risk, because sanctions are not handed out lightly, and when they are even in small amounts, they signal displeasure. The suspense builds as observers wait to see whether the court will view these statements as protected advocacy or as conduct that crosses into unacceptable territory. The situation becomes even more precarious when filings appear that include far more material than necessary, drawing attention not just to what is relevant but to everything surrounding it. Even when redacted, the sheer volume raises eyebrows, because judges notice patterns and repetition, and they remember prior warnings when a court has already struck material from the record and cautioned restraint. The expectation is clear: do not test that patience again. That is why this moment feels so charged, because whether intentional or careless, the inclusion of excessive material creates the impression that someone is playing too close to the edge, and in a case already saturated, With tension, perception matters almost as much as intent. As part 1 closes, the sense of unease lingers because nothing here feels resolved. The subpoenas are blocked, but the conflict continues. The judge remains measured, but the warning signs are visible. This case is no longer just about who is right or wrong, it is about who adapts and who ignores the signals coming from the bench. The pressure is building quietly, relentlessly, and the next move by either side could determine whether this remains a controlled legal battle or escalates into something far more damaging for everyone involved. The tension intensifies as the case moves deeper into unfamiliar territory, where legal procedure collides with public narrative and every action feels amplified under a microscope, because at this stage it is no longer about a single ruling, but about the cumulative effect of choices being made behind the scenes and in plain view. The judge's decision to block the subpoenas does not cool the temperature, it raises it, because it exposes a growing divide between what one side believes it is entitled to uncover and what the court is willing to allow. That divide fuels frustration, and that frustration begins to show not just in motions but in tone, timing, and tactics. The filings continue to stack up at a pace that feels unsustainable, and observers cannot help but notice that the court itself seems increasingly burdened by the volume, the repetition, and the escalating stakes. Each new document feels like an attempt to gain ground, not just legally but psychologically, as if wearing down the opposition or even the court might eventually produce leverage. But courts are not moved by exhaustion, they are moved by precision. And that reality begins to loom larger with every denied request. What becomes clear is that the judge is carefully protecting the structure of the process itself. He is not siding with narratives, he is safeguarding boundaries, and that distinction matters, because when a court starts drawing lines, it is often reacting to behavior that threatens to blur them. The discovery requests are scrutinized not just for relevance, but for necessity and proportionality, and that is where one side repeatedly stumbles. The court acknowledges that some information might be useful, but usefulness alone is not enough to justify intrusion, especially when other paths exist. This is where the judge's language becomes especially telling. He emphasizes alternative means, depositions, targeted discovery, narrower requests. This is not a suggestion, it is a directive wrapped in restraint, and the implication is clear: if those paths are ignored, the court will not be sympathetic. Lateralus, the battle spills into the public sphere. The risks multiply because public statements carry consequences even when legally protected. The litigation privilege offers broad shelter, but it is not limitless. And everyone involved understands that the moment speech appears disconnected from the case or excessively inflammatory, the protection weakens. That is why accusations of improper media engagement strike such a nerve, because they challenge not just conduct, but credibility. One side argues that public statements are defensive, necessary, and directly tied to allegations already made. The other frames them as orchestrated attempts to influence perception and intimidate critics. The truth likely exists somewhere between, but courts do not operate on vibes. They operate on standards, and the standard here is whether the conduct meaningfully interferes with the administration of justice. That bar is high but not unreachable, which is why the threat of sanctions hangs over every interview, quote, and filing. The issue of sanctions itself introduces a new layer of suspense, because sanctions are rarely about punishment alone, they are about signaling. When a judge imposes even a modest monetary sanction, it sends a message to both sides that the court is watching and that patience has limits. It also establishes a record, and records matter, because repeated issues on the same topic invite escalating consequences. The discussion among legal analysts turns increasingly toward whether the court is nearing that point, whether the accumulation of missteps, warnings, and borderline decisions might eventually trigger a stronger response. And that possibility alone changes how the case feels, because it introduces real risk not just for counsel, but for the clients, whose fates are tied to their lawyers' decisions. The controversy surrounding the filing of extensive transcripts only deepens that concern, because it touches on discretion, judgment, and respect for the court. Even when redactions are applied, the decision to include far more material than necessary raises questions about motive. Was it oversight? Was it strategy? Was it a calculated gamble? That the benefits would outweigh the backlash. Judges are acutely aware of how filings can influence public discourse, even indirectly, and they do not appreciate being used as conduits for spectacle. That is why this moment resonates so strongly, because it echoes earlier warnings and suggests a pattern, and patterns are what courts respond to when deciding whether behavior has crossed from zealous advocacy into something problematic. As pressure mounts, the strategic landscape begins to shift subtly. Both sides appear more cautious yet more defensive, aware that the margin for error is shrinking. The judge's approach remains consistent, measured, and disciplined, But the subtext is unmistakable. This case is testing the limits of acceptable conduct. And those limits are being clarified in real time. Every denial, every cautionary phrase, every refusal to indulge expansive requests reinforces the same principle: restraint matters. The suspense comes from not knowing who will adjust and who will double down. Because in high-profile litigation, adaptability often determines survival. And as this chapter unfolds, the sense grows that the court is preparing to enforce discipline more firmly if necessary. The question is not whether consequences are possible, but who will force the issue first. As the case grinds forward, the atmosphere becomes heavier, not louder but more oppressive, because everyone involved now understands that the judge is no longer just resolving disputes, he is managing behavior. And that distinction changes everything. The filings no longer read like simple legal arguments, they read like positioning documents, carefully worded, defensively, almost cautiously, as if each side knows the next mistake will not be forgiven so easily. This is where pressure truly sets in, because restraint under scrutiny is far more difficult than aggression and chaos. The court's earlier rulings begin to function like invisible guardrails, shaping how far each party is willing to lean into confrontation. And yet, despite those guardrails, the tension does not fade. It sharpens, because silence and precision often signal something more strategic happening beneath the surface. Observers start to notice that the judge is using process as a form of discipline, narrowing options, slowing momentum, and forcing both sides to think several moves ahead, rather than reacting emotionally. Conversation around media conduct and litigation privilege refuses to die, because it sits at the center of modern high-profile cases where public opinion can feel almost as powerful as a verdict. The judge has not drawn a bright line publicly, but his earlier decisions suggest a clear philosophy: advocacy is allowed, spectacle is not, defense is permitted, manipulation is not. And the danger for both sides is that the difference between those concepts is often subjective, which means perception becomes critical. That is why every quote, every interview, and every filing now carries weight far beyond its immediate purpose, because it contributes to an overall impression of intent. Judges may rule on law, but they assess credibility constantly, and credibility is built or destroyed incrementally. The suspense here is subtle but intense, because no one knows which action will finally tip the balance from tolerance to intervention. Strategic dilemma becomes even more complex when considering the role of third parties: content creators, media figures, and commentators, who exist in a gray zone adjacent to the litigation. They are not parties to the case yet. They influence its ecosystem and attempts to draw connections between them. And legal teams raise thorny questions about coordination versus coincidence. The judge's earlier refusal to allow invasive discovery into these relationships sends a clear signal that speculation alone will not justify intrusion. That decision protects not just attorneys but the integrity of the process itself. Because once courts allow fishing expeditions based on narrative suspicion, the system begins to erode. Yet the frustration driving those requests does not disappear, it simply redirects. And that redirection can be dangerous if it manifests in more aggressive filings or public accusations. As Part 3 unfolds, the cumulative impact of warnings becomes impossible to ignore. The judge has already struck material from the record, cautioned against overreach, and denied expansive requests, while leaving narrow doors open that require patience. An effort to walk through that pattern suggests a court attempting to de-escalate while maintaining authority, but de-escalation only works if both sides cooperate, and that cooperation feels increasingly fragile. The docket continues to grow, the language tightens, and the margin for forgiveness shrinks. The suspense lies in the possibility that the next filing may be the one that finally crosses the threshold, not because it is dramatic, but because it repeats a mistake already flagged, and repetition is what transforms concern into consequence. In the eyes of a judge, what makes this phase particularly compelling is that no ruling yet has been catastrophic, and that very fact keeps everyone guessing. The absence of severe sanctions does not indicate approval, it indicates restraint, and restraint is often temporary. When tested repeatedly, the legal chessboard is now crowded with half moves and delayed responses, and the question looming over everything is who will miscalculate first. Because in a case defined by pressure accumulation, the breaking point rarely arrives with a bang, it arrives quietly, in a short order, a measured sanction, or a sharply worded ruling that changes the trajectory overnight. And as this part closes, the sense is unmistakable: the court is watching closely. The patience is thinning, and the next chapter may be defined less by arguments and more by accountability. As the case reaches this stage, the feeling is no longer chaotic, but calculated, because every participant now understands that the courtroom has become a pressure chamber where restraint is being tested. rather than ignored. The judge's role has subtly evolved from referee to regulator, not through dramatic speeches but through quiet consistency. Each denial, each narrowed allowance, and each carefully chosen phrase in the order signals that the court is focused on preserving structure over spectacle, and that focus reshapes the battlefield entirely. The parties are no longer fighting only each other, they are adjusting to the boundaries being reinforced in real time, and that adjustment creates tension because it forces strategic recalibration under scrutiny. The filings grow more deliberate, the language more defensive, and the tone more cautious, yet beneath that caution the conflict continues to simmer. Because unresolved accusations do not disappear, they weigh. The looming question of sanctions now hangs heavier than ever, because it represents the court's ultimate tool for enforcing discipline. Short of dismissals or evidentiary penalties, sanctions are the clearest expression of judicial displeasure, and even modest ones carry outsized symbolic weight. The possibility of a financial penalty is less significant than what it implies: a warning shot, a record entry, and a signal that the court's tolerance has been tested. When prior cautions are followed by conduct that appears careless or excessive, the judge does not need to infer intent, he only needs to observe pattern, and patterns have begun to emerge through repeated overreach, attachments that go further than necessary, and arguments that press against previously articulated limits. The suspense lies in whether the court will choose to intervene decisively now or continue allowing incremental correction in hopes that the message finally lands. At the same time, the broader implications of this case ripple outward, because it exists at the intersection of litigation, media, and public narrative. In an era where court filings are instantly dissected online, the responsibility carried by attorneys is heavier than ever, and judges are acutely aware of that reality. They know that what appears on a docket can shape perception even without explicit commentary, and that awareness informs their patience and their warnings. This is why the inclusion of excessive material feels so consequential, not because it changes the facts, but because it tests the court's role in controlling how the case is presented. Beyond the courtroom walls, the judge's restraint thus far suggests a desire to avoid becoming part of the spectacle, yet restraint should not be mistaken for indifference. It is often a precursor to firmer action if the conduct continues as this part concludes. The atmosphere is defined by anticipation rather than action. The subpoenas remain blocked, the privilege boundaries reinforced, and the path forward narrowed to more traditional discovery channels. Yet the underlying conflict persists, fueled by frustration, narrative clashes, and the ever-present risk of misjudgment. The court has drawn its lines clearly enough that no one can claim surprise if consequences follow. The only unknown is timing, whether the next filing will respect those lines or test them again. And that uncertainty is what keeps the tension alive. Because in a case like this, the decisive moment is rarely the loudest, it is the moment when patience runs out and the court decides it has done enough to warn and must now act. This case is no longer about a single ruling or a single filing. It is about pressure, discipline, and who blinks first inside a courtroom where patience is clearly wearing thin. The judge has drawn boundaries, warned both sides, and slowed the pace, but the tension has not eased, it has sharpened, and now every move matters, because the next mistake may not come with another warning, it may come with consequences that reshape everything. Stay with this story, because what happens next will not be loud. It will be decisive.